Welcome, everyone, to this week's edition of the Altman Health Talks. My name is Vi Leggett, and I happen to have the honor and privilege of introducing our speaker today, Madison Chapanar, who's going to kind of walk through the basics of estate planning. And I can share from a personal message that my husband and I just had to work through this entire process with a family member. And I certainly wish I would have had the opportunity to hear Madison before we walk through that process. So what I can say, it's never too early to begin estate planning, and it's never too late to begin estate planning and really dig into what is important to you and your family moving forward. So Madison is going to share a little bit about herself in the slide presentation, so I won't take that away from her, but I am really excited that all of you have agreed to join us today as part of the Altman Health Talk series and coordinated by the Altman Foundation. So Madison, welcome, and thank you very much.
Thank you, Vi. So I'm going to share my screen with you so you can see my presentation. So just give me a minute here. Okay, so yes, as Vi said, my name's Madison Chapanar. I am an attorney at Krugliak, Wilkins, Griffiths, and Doherty. I've been here since 2018 when I started as a clerk while I was in law school. And then once I was admitted to the bar after graduation, I became a full-time attorney here in 2020. I mainly work in the Canton office and Massillon office, so in Stark County. I grew up in Stark County, been here most of my life, so Stark County holds a good place in my heart. I primarily practice in estate planning. So when I say estate planning, I'm talking about drafting wills, trusts, powers of attorney, guardianships, probate administration, trust administration, asset protection for Medicaid, everything like that. So without further ado, I'm just going to dive right into what an estate plan is. If you have any questions, feel free to use the chat. I'll try to get to as many as possible. And then I also do have I've saved some time at the end so that we can go over any questions you might have. But I will say what I'm about to talk about today really is generalized advice. So I hope that you get something out of it, and I hope that it's helpful for you. But an estate plan is extremely customized to each individual client. So everything I'm saying is very generalized. So hopefully you take it that way. And if you have specific questions, of course, we can set up a meeting to talk about those. But historically, an estate plan was maybe a will, maybe powers of attorney, and just about everybody went through probate. And I'm going to talk in a little bit about what probate is. But basically, that was historically what an estate plan was. Everyone went through probate after they died in order to administer their assets to make sure they got to somebody. In modern times, it doesn't necessarily have to be that way. So there's a lot of laws and tools that can be used to make sure that you can avoid probate if that's what you would like to do, that your administration is a little bit easier on those you leave behind, because administering an estate can be a lot of work for our loved ones that end up having to handle that for us. So there's ways to make that a lot easier on them. And there's also more ways now for customized, a comprehensive detailed plan. So you can basically do whatever you want these days with an estate plan. Even in Ohio, you can do a pet trust. You can leave money to your pets. You can leave money, to charities, to beneficiaries, to anything you would really like, and in any way you would really like. So it's really customized these days, and it makes it a lot nicer and easier for those we leave behind. But before we get into that, what an estate plan is after death, I really want to talk about what an estate plan means while you're living. So while we're alive, we are making decisions for ourselves. I make my decisions as to my doctors and my finances, but what happens when you become incapacitated? We really need to focus on, hey, if I become incapacitated, whether by, I could get in a car accident on my way home, I could fall over and hit my head and have a traumatic brain injury. Who is going to make my decisions for me? Who is going to pay my bills? Who is going to decide if I'm having surgery or not? Who is going to do that sort of thing for me? From a overall perspective, the law kind of looks at each person as two parts. They look at you as part of you being medical and part of you being financial. Now, obviously, there's way more to us than that, but that's kind of how the law breaks it down. From a medical perspective, if I got in a car accident on the way home, who would make my medical decisions for me? If I have a healthcare power of attorney, my agent under the healthcare power of attorney is going to make those decisions for me. If I don't, go to bullet 3 there. A guardian will make those decisions for you. We'll get to that later. From a financial perspective, if I got in a car accident on the way home or whatever, I had to have surgery and somebody needs to make financial decisions for me, who's going to make those? My financial power of attorney is going to make those if I have one. If not, default to guardianship. And I'll make a note here. We'll talk about this in a minute or two, but a power of attorney for property goes by a lot of different names. Some people call it a financial power of attorney. Some people call it a power of attorney for property. Some people call it a durable power of attorney for property. It all means the same thing. So if you hear me use those words interchangeably, usually I call it a durable power of attorney for property because that's what Ohio calls it, but it all means the same thing. It's the person that's making your financial decisions for you. And then we'll talk about guardianship being the default. We're going to start with healthcare powers of attorney. So this document designates someone to make healthcare decisions for you if you no longer can do it. So if you no longer can make your medical decisions, you should designate someone to do that for you. This should be durable. It should last your duration. It should continue on for as long as you want it to. Now, with that being said, you can always revoke it and change it and update it. But the document itself should say, that it goes your duration. It should contain a HIPAA release. And it should state what you want in an end-of-life state. Now, a healthcare power of attorney in Ohio, there is a group of doctors, lawyers, people that put together a form that that should be typically used because that's what doctors are used to seeing. And you can get that form anywhere. And so sometimes I get questions all the time as why can't I just download this form and fill it out myself? Why can't I just go to Office Max and get an estate plan book and fill that out? And, you could, of course, but my answer always is because I don't know if you're going to do it properly. And the reason I say that is if you have one of these healthcare powers of attorney, I have one, of course, there's lots of spots for you to initial. There's a spot to sign. There's blanks. It's a lot. So you want to make sure you're executing it properly. For example, there is a spot on that document where you need to initial saying that you are granting your agent the ability to get your protected HIPAA information. And you might be thinking, well, of course, I want them to have my medical information to make decisions for me, but you actually have to grant your agent that authority. And so it's important to make sure you're executing it properly. The document also has a big paragraph. It should, if you have a proper document, and it should state what you want in an end-of-life state. And what I mean is the verbiage says something that to the effect of, if you are in a permanently unconscious state or at the end of a terminal illness and 2 doctors certified to a reasonable degree of medical certainty, providing you artificial nutrition or hydration will not bring you back to consciousness or relieve pain or do anything productive for you, you are granting your agent, if you initial that box, to make the decision whether or not to remove you from artificial nutrition and hydration. It's a very specific language, very specific verbiage. And you can initial that or you cannot initial that. And again, if you initial it, you're just giving your agent the authority to make that decision for you. Now, that same verbiage is in the living will. That's actually the only thing that's in the living will. And I'm going to take a second to explain this because I think one of the number one misconceptions I get is that a client tells me they have a will and I have to ask some questions because sometimes, and rightfully so, everything has the same name, so it's easy to get confused. But a living will is not the same thing as a last will and testament. A last will and testament is after death. It's an instruction manual to the probate court. We're going to get to that. A living will is an advance directive. It looks a lot like a healthcare power of attorney. It is an optional document. I would say that every single person above the age of 18 needs to have a healthcare power of attorney, but a living will is completely optional. And what is the option you're making? A living will states that you do not want to be maintained in the end of a terminal illness or a permanently unconscious state if 2 doctors certified that to a reasonable degree of medical certainty, providing you artificial nutrition or hydration will not bring you back to consciousness or relieve pain. It is you making that decision. It's you saying, I know what I want. I don't want to be maintained in that state. I want everyone to know. It's a directive to the healthcare community. Now, the living will controls in that specific instance over the healthcare power of attorney. And when I'm saying it's completely optional, there's basically 2 schools of thought. And I would say, clients clock in about 50-50. There's no right or wrong. Some clients think that, I know what I want. I don't want that burden to be on anyone's shoulder to have to, remove me from artificial nutrition or hydration. I know what I want. I want a living will. And the living will does have people listed in there just as contacts, people that need to be notified by the doctor. The other school of thought is, that's all fine. I want to make sure somebody can make that decision for me, but I'm not sure I want it to be automatic. I'd rather have my agent be the gatekeeper. I want my agent to make that decision. Fine. But it's good to, think that through. It's an important question. And I get a lot of clients too. It gets complicated because you'll get asked a lot if you have a living will. You'll get asked at the doctor. You'll get asked at the BMB now. They'll put it on the back of your license. So clients automatically think I need to have one. Not necessarily, it's optional. So it's really a personal decision. But I really just wanted to make the distinction that a living will is not a healthcare power of attorney and a living will is not a last will and testament. So all of that was for your healthcare decisions. What about financial decisions? Who is going to pay your bills for you if you can't do it? Who is going to handle all of your finances? That would be under a power of attorney for property. Again, financial power of attorney. Property is taken in the broad sense. It means everything that you own. Now, not all powers of attorney are created equal. Unlike the healthcare power of attorney, where there's basically a standard format, the durable power of attorney for property, it's not the same. Attorneys kind of use whatever, they draft their own thing typically. Now, there is a statute in Ohio that governs this. They call it called the durable power of attorney. There's a power of attorney act. And it does have suggested formatting, which is what we use. But not all of them are like that. And if you have an older power of attorney that's, 10, 20 years old, it probably doesn't have what it needs to have anymore. And what am I talking about? Well, there's standard powers that are in a power of attorney. What you think about when you think about becoming incapacitated, who's going to write your checks? Who can pay your bills? Who can access your bank account? Who can go to the BMB and handle your car tags? But then there's some extra things in there that if it's a good power of attorney, it will have it in there. They're called special powers or hot powers, and they are bulked up powers that are used for specific circumstances. The number one hot power is about gifting and making trusts, and that is very, very, very important if you were ever to need Medicaid and your family or your agent wanted to try and protect some of your assets if you were in that circumstance. And if your power of attorney does not have that power, there is nothing that can be done. You can't even go to the court under guardianship and do it. It's just end of the road. So it's really important that you have a good power of attorney for property. It's also very important that it's durable, that it lasts the duration. Banks really want to see that I talk to banks a lot, turning in documents, if they call us and the client needs a document, and it needs to be durable. It needs to say that it lasts the duration. Now, that's all fine, but what if I got in my car accident on the way home and I didn't have those documents? Who's going to make those decisions for me? There's a default. I hate to say it's not the best default, but there is a default, and that is guardianship. What is guardianship? Guardianship is governed by the probate court in the county where the person is. So, if I got in my car accident on the way home, Stark County probate court is going to handle my guardianship. And, somebody realizes, hey, we need to make financial decisions for her. We need to make medical decisions for her. So they would go to the probate court and they would apply to be my guardian. Either guardian of my person, which is medical decisions, guardian of my estate, which is financial decisions, or both. So when is a guardianship needed? It's needed if you don't have powers of attorney or if your powers of attorney weren't effective. And what do I mean by effective? If you have powers of attorney and they only name one agent and that agent dies or that agent isn't around anymore or something happened to them and you don't have a backup named, your power of attorney is not effective. There's no one else to help you. So it's really, I always encourage clients, as long as you trust someone, name backup agents. It's so, so important. And it also makes your document last longer. It's more bang for your buck, the more agents that you list in there. And if you don't have powers of attorney in general, guardianship is going to be needed. Now, why would you not want to do guardianship? The probate court is great. There's nothing wrong with the probate court, but guardianship is a lot. One, it takes longer. If I have an agent under a document, they can immediately act for me as soon as they have the document. They don't have to go to probate court and apply. And if you're a financial guardian of the estate, get bonded, turn in reports. It's a lot. It's a lot for an agent. And usually when this comes up, families are already going through a lot. I mean, somebody is incapacitated. That is stressful to begin with. And now they're trying to pick up the pieces and make sure they're taken care of. So it's just a lot. So if we can avoid it by having good, strong powers of attorney, it's very much suggested. So everything I was just talking about is while a person is alive. It has nothing to do with after death, because your powers of attorney live with you and they die with you. So if I died today, my agent under my financial power of attorney for property cannot go to the bank tomorrow and write a check or take money out or do anything like that. That is illegal. That's theft. That's fraud. Can't do that. And people don't know that. And it's not that people necessarily are doing it on purpose, but they just think, well, I have a power of attorney. That agent will be able to handle everything for me. While you're living, yes. After you die, no. Your powers of attorney die with you. So then after you die, who is there to pick up the pieces and handle your affairs? There's a few people in those roles. For funeral decisions, there's actually a document now that we draft, and there's a statute about it, that you can appoint someone to be a representative that can kind of make any decisions to the extent they're not already made for funeral purposes. So that's nice. For everything else, it's either going to be an executor under the will or a trustee under a trust or both. Hopefully, we'll get to that. So when you pass away, what happens to your assets? That's what everybody wants to know. When I die, what's going to happen? Well, it depends. And that's the best lawyerly answer, and everybody hates it, but it really does depend. So historically, like I said earlier, when somebody died, all their assets just went through probate. Their will would control, because your last will and testament controls what goes through probate. Modern laws have changed that. There's ways to avoid probate now. And it's the same thing, like I said, with guardianship. There's nothing wrong with the probate court, but it's a long process. If you have been through it with a family member, you know how hard probate can be and how long it takes and how much money it costs. And so if we can avoid it, we typically would want to. So what are those modern laws? Well, there's a few ways that you can avoid probate that are prescribed by law. And if you're a person like me that needs an example or a visual, just hang on, because I have one of those to go through with you. But for now, we're just going to kind of talk about it. So the first way is through titling. So holding ownership joint with right of survivorship, and then using beneficiary designations. Using trusts when they're used properly, that would avoid probate. And then probate is still there as a catch-all. No matter what, I always recommend a client has a will. A lot of times clients are like, well, you just told me how to avoid probate. I don't need a will. You need a will. Everybody needs a will, because the will is a safety net. It names an executor. It handles any assets that weren't titled properly. Everyone should still have a last will and testament. So we're going to go through these. So the first kind of way to avoid probate is how you hold an asset. And what I mean by that is, how is it titled? Joint with right of survivorship. You often hear about this for property, for real estate. You might own property with someone, with a spouse or anybody, joint with right of survivorship. And if you do that, and if it's effective, so on your deed, if it says that you own property with so-and-so, joint for your lives, remainder of the survivor review, or some language like that, then it goes automatically to the survivor on death. So if you own a home with your husband or wife or spouse or whatever, and you own it jointly with right of survivorship, if the deed has that special language, if one of you passes away, the other one automatically gets it. It avoids probate. The same as with bank accounts. A lot of times bank accounts you can own jointly with someone as a co-owner. Investment accounts, it's the same way. You can also do that with vehicles. So upon death, the surviving owner gets it. Now, that only avoids probate on the first death. When the survivor dies, then you need to make sure you're updating things. So just know that, joint with right of survivorship is great, but it only avoids probate on that first death. And I always talk about that with clients too, we can do things to make sure it's structured to kind of last the duration. Beneficiary designations. So this is another way to avoid probate. And you can put these on just about any asset you own. You can put a beneficiary designation on. They're called different things depending on the asset, but just know it all means the same thing. I don't know. I'm sure there's some historical reason why they have all these different names, but it means the same thing. If you have a bank account, a beneficiary designation is called a payable on death designation. If you have real estate or a car or stocks and bonds, a brokerage account, it's called a transfer on death designation. And if you have life insurance or retirement accounts, annuities, anything like that, it's called a beneficiary designation. But again, it all means the same thing. It means you're picking someone to receive the asset on your death outside of probate. And how that works is, let's say that I name Joe Smith to be the beneficiary on my retirement account. When I die, he gets a claim form in the mail and he turns in my death certificate, answers some questions, and he just gets it. He gets it outside of probate and no one else is involved. Trusts. So there's a lot out there about trusts, and I'm not going to go real in depth about trusts today because this is more of an overview, but I want you to know a few things. First of all, I want you to know that there are so many different types of trusts out there. They come in two main categories: revocable and irrevocable. And much like it sounds, a revocable trust can be changed while you're living. If you set up a trust that's revocable, you can change it, update it, amend it, whatever you want. An irrevocable trust, like it sounds, cannot be changed. You set it up and that is it. An irrevocable trust is used for a very specific purpose. There's lots of different types, but an irrevocable trust is used for a specific purpose. Not everyone needs an irrevocable trust. Not everybody needs a revocable trust either, but just know there is a difference. And an irrevocable trust, you would need a very specific purpose to have that. But a revocable trust is very common, very popular. It's used to avoid probate. And you might say, well, you just told me all I have to do is name beneficiaries on my accounts and then I can avoid probate. Well, that's true. But if you name a beneficiary on anything, they just get it. They file their claim forms and it's theirs. There's no information in there about what if that person dies. There's no information in there about how they should get it. If they're young, if they should get it, at certain ages. There's nothing in there that says what happens if they pass away and they still have money left. And there's also nobody in charge. If you just name beneficiaries on everything, who's in charge to pay your bills, your final bills? Who's going to pay the funeral bill? Who's going to pay any final housing expenses? There's nobody really in charge. So a trust is nice because it's kind of a blend. It's like a will. It says where your assets should go. You can put all sorts of contingencies in there. You can put all sorts of different ways people get their assets in there. But it avoids probate still. You just have to name the trust as the beneficiary. You update your beneficiary designations and you name the trust. You can have an individual trust in your own name. You can have a joint trust with your spouse. So they are nice. Now, I will say, not everybody needs a trust. Trusts are great, but not everyone needs one. And like I said in the beginning, an estate plan is extremely customized. I get a lot of calls and people want to know immediately, well, what do I need? I have no idea what you need. I don't know what your life is like. I don't know who you want to get assets, or if you have charitable, you want to name charities, or what you want to do. So after a meeting, when we sit down and we go through what you want, then I would be able to say, yeah, a trust makes sense in your case, or, you don't need a trust. You can handle it this way. So not everyone needs a trust. So I don't want you to think that, you have to have one. But what are some examples of when a trust might be needed? Now, these are not exclusive, but these are some common ones. A trust is private. So your will, if your will ever needs filed, it gets filed at the probate court and it's public forever. You can get on Stark County Probate Court's website right now, and you can type in some random name and you can look at trusts. You can look at the whole wills. You can look at the whole docket. You can look at everything that happened in a probate estate. So you can basically see everything about who that person gave money to. A trust never gets filed anywhere. A trust is private. It's just private to you. So some people that don't want their business out there, they prefer trusts for that reason. If you want control after death a little bit. So for example, blended families, sometimes, for a blended family, someone gets remarried later, but they still want to make sure that any children they had from their first relationship still get something. They're useful in that situation. Minor children, if you want a minor to receive assets and you don't use a trust, we're going back to guardianship. We're going to guardianship of the estate. So to avoid that, people use a trust. If you want to give someone money that might not be the best at handling it, or might be a spendthrift, or might have creditor problems, a trust makes sense. Or if you have a complex distribution, if you came in and told me you want this person to get 5%, this person to get 10%, this charity to get 50%, you had all these things, a trust is a lot easier to do that. It also just makes it a nice, clean, centralized funnel. It funnels all the assets into the bucket. The trustee, a person that you trust who's in charge, makes the decisions for you, or pays all your bills for you. They kind of act as you would have, and then they distribute property. A trust is also extremely useful in real estate transfers, especially if you own real estate in another state. So if you own property in another state and you pass away owning that property solely in your name, you're going to have to, your survivors are going to have to probate in that state. So they might have to probate in multiple different states. So to avoid that, a trust is very useful in that particular circumstance. So after I said all these things, titling and beneficiary designations and trusts, what does your will control? Well, your last will and testament controls anything that's left. Anything that you owned solely in your name when you passed away without a beneficiary designation has to be probated. So those are what are called probate assets. So if someone passes away, when their family comes in and we sit down and we try and figure out what's left, we go asset by asset. Tell me everything they owned. And then we go to the next step. Who owned it? Whose name was on it? Was there beneficiary designations on it? That's how we figure out what needs to be probated. Your will also names an executor for you. Now, that's another reason why, even if you can avoid probate, you should still have a will. You should still name an executor, because an executor might need to be appointed for some other purpose that actually doesn't have to do with probate. You might not have to probate, but you might need your executor appointed to maybe sign a final tax return or something like that. A will also names guardians. If you have minor children, a will names guardians. And again, your will might not need to be filed because you had any probate assets. We might need to file it to show the court who you named as a guardian for your minor children. The will should waive bonds so that your executor doesn't have to post a bond. If you don't have a will, there's some defaults to this, but typically if you don't have a will, that means you died intestate and you don't have an executor, you have an administrator, and the administrator is going to have to post a bond. They're going to have to go through procedures that if you had a will, they wouldn't have had to. So summary of ways of avoiding probate: titling of your assets, adding a beneficiary designation, using a trust. And before I get into my example, I also just wanted to state that there's some other times when probate makes sense. So I like to say that titling and fighting. So if you don't title stuff properly, you're going to, your family's going to probate. If people are fighting, probate court's probably where they should be, because the judge oversees it all. They can figure it out. When someone's will gets challenged or somebody is fighting over how an asset should be distributed, probate court is better. And I'll use an example for that. Like I said earlier, you can put a transfer on death designation on real estate. So I could own a home and I could say, when I die, I want it to go to these 4 people. And then when I die, those 4 people become the owners. They each have a 4th share in that real estate. If I named 4 people, maybe they're my 4 kids, and they don't get along, that is a problem. If they do not get along, it is going to be very, very bad. So if you know that's going to happen right off the bat, it's better just to go through probate. It's better not to do the TOD, and then the court will figure it out. They will oversee it and they will figure it out. So probate is a great tool, but most people don't have to go through probate. So I just want to point out that there are instances where I might say, let's just use the will. Let's go through probate, force everything through probate. Not always, but sometimes it does happen. But again, summary of how to avoid probate: having your assets titled joint with right of survivorship, adding a beneficiary designation like a payable on death, transfer on death, or just a beneficiary designation, and using a trust when you name the trust as the beneficiary. So we're going to go through an example. So let's say that I die tomorrow, and I die and I owned a home with my friend John, and on our deed, it said that we owned it jointly among the two, or between the two of us, all to the survivor of us, in the survivorship language. Let's say I owned a bank account. That's my checking account I used for my bills, and it's solely in my name. I didn't put a payable on death designation on it. It's just in my name. And let's say I have a life insurance policy, and the policy named my mom as the beneficiary. I also have a will. My will said everything I own, I want everything I own to go to my friend Mary. So I die. What happens? Well, the home automatically goes to John. John gets the home. He is the joint owner with rights of survivorship. He automatically gets it. He would just have to record something with my death certificate. It's an affidavit that says that we owned it jointly with rights of survivorship. I died. Now it's his. We're going to skip the bank account for a second. The life insurance policy goes to my mom. She is the named beneficiary. She just gets a thing in the mail that says she's a beneficiary of this life insurance policy. She files a claim form with my death certificate. She gets it. What about my bank account? Well, my will said I wanted everything to go to Mary. Mary is only getting my bank account. She's getting the account that might not have anything in it, might have a couple $100s in it. And in order to get that bank account, she has to file my will with the probate court. See, the home was owned joint with rights of survivorship. So John owns it. He has automatic access to it. The life insurance policy named my mom. She has access to it because she's the named beneficiary. The bank account had no name on it. And like I said, I no longer have a power of attorney because I died. My power of attorney cannot access that anymore. The only person that can access that now is an executor or a trustee. Well, there's no trust in this example. I just have a will, and the bank account wasn't named to go to a trust because I didn't have one. So Mary has to file my probate court, or file my will with the probate court and probate my estate. She has to file initial documents. She has to get appointed as executor. If she's named executor, whoever's named as executor in the will will get appointed. That we'll say for this example, Mary is also the executor. So she has to file the will. She has to go through the hoops. She files an inventory. After she files the inventory, then she makes sure there's no bills that need to be paid, that no claims come in against my estate. Then at the end of all that, she'll file an accounting. And then if the will says all to her, she gets whatever's left. But first, the attorney fees get paid, court costs get paid. If the fiduciary, if she was the executor and wanted to take a fee, she would do that. And then she gets whatever's left. So as you can see, I'm not trying to illustrate much by this example, except for showing that in certain instances, it's a lot easier than in others. So, and not to say that probate court there's nothing wrong with it, but a lot of people just want to know how they can avoid it. And usually it's people that have recently been through probate, just knowing how long it is really, how much it costs, how long it is. And just, it's not really necessary for everybody. Key takeaways that I hope you got from this presentation: powers of attorney are extremely important. I would argue they might be the most important documents because, once you die, you're on to better places, and, you want to make things easy for your family. But after you die, it'll get figured out. It's a lot harder to get figured out while you're alive, but incapacitated. So powers of attorney are so important. Knowing that you're naming people that you trust. Powers of attorney are extremely strong, powerful documents. You need to make sure that you name people that you trust to make those decisions for you. But having them is important. Asset titling, that is what controls upon death, not your will. Your trust will only control if you titled those assets to go to your trust when you passed away. But asset titling, that's what controls. Just because you have a will that says all to your friend Mary does not mean Mary is getting anything unless everything went through probate. And lastly, of course, how to avoid probate, the different ways.